all rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number 1 JV23 in the termination of parental rights as to CD. Council, just to remind you, we're recording and live streaming the argument, so please identify yourselves at the beginning of your arguments. Each of you will have 20 minutes. Council Appellant, you're responsible to watch the clock and reserve as much time as you desire for rebuttal. Also, please keep in mind we've read the briefs, we've read the record and studied it, and we've also discussed this case in conference. And with that, Counsel for Appellant, you may proceed.
Good morning. May it please the court. I'm Edward Johnson here on behalf of the father, Aaron D., who's present in the courtroom seated in the front row. On December the 21st of 2022, the Department of Child Safety filed DCS's motion for termination of, and I quote, parent-child, end quote, relationship. The ultimate question before the court is, can the juvenile court terminate a parent-child relationship based on abandonment when paternity has not yet been established? I submit the answer to that question is no. Since this court gave us the decision in dependency regarding GR, there's been a question that's come forward many times. And the question that we seem to get most often is, one, does it relate back to dependency findings that have already been made prior to GR? And the second question is, were the limited circumstances that were mentioned in GR the only point in which the parent relationship can be contemplated? I would suggest to this court that dependencies, we know the term of law that statutes don't go retroactively, but case law, unless it's specifically stated, can apply retroactively. In this case, we believe that the dependency finding should also be undone, but that wasn't a matter that this court asked for the question on the supplemental briefing. But as far as the court would like me to indulge, I would say that the parent-child relationship, the sole basis for that finding, as the state pointed out, was that under 201-15A1, there was no parental care and control. There was not an effective parental care and control because there was no parent or guardian able or willing to exercise care and control. I think this court in GR made it clear that dependency in this case should not stand based on the decision and the holding in GR. Specifically, GR noted that because paternity proceedings take precedence over all other civil proceedings, we hold that in dependency proceeding, the parties must address and the court must resolve relevant paternity issues before the court determines dependency. And of course, we know that didn't happen here.
Well, counsel, the two things, though. That wasn't in your notice of appeal, was it?
What was not in my notice?
The issue of the dependency was not in the notice of appeal.
That's accurate.
And it also, no appeal was brought timely after that order became final, correct?
That's also accurate.
All right. So what jurisdiction do we have to even touch that?
Well, I believe this court always has an ongoing obligation to assume jurisdiction, to look at jurisdiction. You know, personal jurisdiction we know can be waived, but subject matter jurisdiction cannot. So I believe if the court finds that jurisdiction was never valid, never proper, that the court has an obligation and a duty to right that wrong.
Okay.
The court found in GR, of course, that the department had alleged Adrian, and that the father in that case was unwilling or unable to provide proper and effective parental care and control due to abandonment. And the court defined abandonment pursuant to 8201. And that, of course, says that there's a failure of the parent to provide reasonable support to maintain regular contact with the child. And for the court to find that Adrian had abandoned the child, the court would need to find first that that was the child's parent.
So, counsel, how after GR are we to harmonize B1 with F?
It's a great question. When I look at that, let me fast forward a little bit. First, I think F doesn't really apply here, and I'll tell you why. I could be wrong. Candidly, it could be totally wrong. It could be almost like when my son asked me, hey, Dad, where's the barbecue sauce? And I say it's in the fridge, and he looks all through the fridge and says you can't find it. I'm like, it's right in front of you. So I could be totally wrong. I went through the record multiple times. I cannot find anywhere in this record where the department requested the father to take a paternity test. I can't see where the court ordered it. And of course, we know F says that the failure of an alleged parent who's not the legal parent to take a test requested by the department or ordered by the court. They knew from the outset that paternity was an issue. We see it in the PPH order setting hearings that paternity was an issue. The first minute entry from the PPH says paternity has not been established. Then we go to the mediation conference, and in the mediation note, the parties agree, and it says the department is willing to accept an acknowledgement of paternity if father chooses to do so. If not, the department agrees to provide a paternity test for father. That's it. That's the last mention you will see on paternity. I scoured the entire record, including the 3 exhibits from the trial, which were the court reports. Nowhere does it mention paternity testing at all in the court reports or as a service provided for father. The next time that you ever see anything about the paternity test is in the 23-minute hearing, the Termination of Parental Rights, where the case manager is asked a series of questions. Did you offer it? Yes. When did you do it? At the beginning of the dependency. And did he take it? No. Short of that, I can't find anywhere in here where the department requested father to do it.
I didn't want to interrupt your answer because
I appreciate that.
Because that's a very good detailed answer to that shouldn't concern us in this case, and you developed the facts well. But nonetheless, I still remain interested and concerned. How do we harmonize B1, which refers only to parent, and F, which does discuss abandonment, but in the context of an alleged parent? How do we get those to work together, understanding your first point?
Okay, so assuming my first point is out, I think F works in conjunction with B1, and I think it harmonizes, almost like the statute definition. I think it's in 201, where it talks about no contact for the 6 months is also prima facie a case of abandonment. So I think it's just another tool to try to get you there. I think my argument would be that we never made it to B1 because of the parent establishment, parent relationship is just not there. So we see it today frequently ever since GR. The department now doesn't motion to terminate parental rights in a case like this. They petition separately in a JS case as opposed to the JD case to terminate parental rights in a case just like this, which I think is the appropriate vehicle to do it in such a case.
So satisfying F, can you satisfy F with someone who is not conclusively demonstrated to be the parent and terminate them under B1 or not?
I believe no.
Okay.
And counsel,
Yes, sir.
when you read F, isn't F just establishing that if a parent, for example, delays, doesn't take, but ultimately is just found to be the parent in whatever mechanism, perhaps ultimately does a voluntary acknowledgement of paternity, or 2 years in, finally takes the paternity test, that the failure, that delay, is evidence of abandonment because they could have done that 2 years earlier. And that is how it ties in. Would that be a fair reading of F?
So I'm not a legal giant like yourselves, but that was my understanding as well. And I think when we talk about the first definition, the 6 months of no contact, I think many times we file a petition and then the parent makes contact. And the court then says, well, I'm sorry, but you had 7 months of no contact. Now that you're having 2 months, we still have that first 6 months period. So I think it kind of ties in similar to that. I think when you look at the very beginning of 8533, it says you can terminate based on these grounds. And of course, it's not listed under there. It's a whole separate subsection, which to me means it can be taken in conjunction with, but it's not a standalone ground. And it's not something I can just use by itself.
And I'm not going to claim to be a legal giant. I just happen to be sitting on this side of the bench, so never attribute that. But the state also has a mechanism besides just requesting to actually establish the paternity, which is 25-813. If the state felt, and the state could have in this case, filed a motion, said please order him to take the test, and if it was scheduled and he didn't take it and didn't have good cause, the state could ask for a finding of paternity by default.
Absolutely.
That's the mechanism that allows them to get to the paternity finding. Is there anything in F that says that will establish paternity?
Not enough, and certainly.
It's just evidence of the abandonment,
Absolutely.
but not of parentage.
Correct.
Okay.
So I still think we have to get to the link of the whole parent part of that relationship in order for that to then be sufficient. And again, I don't believe that that's met here, and I do think this court in GR laid out the mechanisms as you just detailed in the footnote about how that paternity can be established whenever there's no other mechanism of doing it, or people just are reluctant to do it for whatever reason.
If I could follow up on I'm still thinking about the relationship of B1 and F. Could you please comment on a point that intrigued me in the government's supplemental briefing? The government says that 533 contains several subsections that plainly authorize the juvenile court to terminate the parental rights of a parent who has not established paternity, and they cite parts 5 and
Sure.
part 6. Can you explain, first, do you agree with that? And then second, if you do, how do you reconcile that with your answer about B1 and F?
Yeah, so I dare to ever disagree with Ms. Williams, who I've known as just for a long time. But I will tell you, I think the sections that she quotes, and I've used those frequently myself, I primarily do adoptions. I think we use those all the time for private adoptions and in cases like that. So I do think that that's the mechanism to do it for a private adoption, the putative father registry, the notice of potential birth father. I think all those are legally great mechanisms to terminate the parental rights when it's not clearly established or all you have is a mom saying this is the father. But I think I just think that it's irrelevant in a case like this.
So we can terminate sometimes under 5 and 6 the parental rights of a parent who has not established paternity. You just don't think it works with B1 and F.
Well, I don't think you can do it as a standalone. I think there's other documents, there's other things you have to do to get to 5 and 6. You have to do the notice in the paper. You have to do the putative father registry search. So I think there are other requirements that do it. It's not just a standalone. It's not as easy as that. There are other requirements that kind of go along with it, which is why I don't think it would be applicable in a case like this.
Well, counsel, it's fair to say, that paternity is never actually established under 5 and 6.
Correct.
It's never truly established.
Correct.
So would a fair reading, and I'm not certain we need to get there because we're looking at just the language of 1 and 2. But when we look at 5 and 6, is a fair reading of them to be the exception to the rule? In other words, the statute starts in Jonathan Rowe's statutory interpretation. Start with the first sentence. The petition has to be to terminate the parental rights. The evidence has to support a ground to terminate parental rights. It seems that those two are a way to deal with it when they haven't, and as you said, in some unique circumstances. I've talked quite a while, but what I'm trying to line up is, aren't those two really just exceptions to the general rule? Because I don't know that we can harmonize them.
Agreed, and I think that's why when you talk about when they're used, like when do you actually put those into play? And I think that's most often on a private adoption side, and I think it makes sense in those contexts to figure out kind of, not to get into the political thing, but why do some people go for the private adoption route? It could be because of sexual assault. It could be they're just not in a position to parent. It could be because of infidelity, so they can't raise a child. So in those circumstances, it may be awkward. You may not know who a father is. It may have been a one-night stand. It may have been a bad decision. Definitely not the cases in something like this. So I think in those unique circumstances, you have to have a mechanism to try to do an adoption or to do a severance. And if those
And generally,
weren't there,
DCS isn't even involved in this.
Correct. Those are
given notice
private.
and they don't even get involved because
Exactly.
of the way it works.
So I think those are there to give somebody, there has to be another way of doing it aside from just the other statutory subsections.
So under 5 and 6, are you familiar, have you ever seen a petition or motion by DCS that only alleges subsection 5 or 6?
I have not.
As a ground for severance?
I have not. It may be out
Are you
there.
aware
but
of any case law that
not that I've seen. I've only been doing this, 12 or 13 years. I've been on, I'd say, several thousand cases. I have not seen it come across. It very well may have, but I haven't seen that as a mechanism that the department has typically used to terminate parental rights. So further, again, I couldn't find anywhere in the record to support that the department had requested father to actually take that testing. So we would just submit to the court that he was never asked to do that test, that he was going to do it on his own. And we now know that paternity had been established later on through the grandmother as they were vetting her out for placement, but that was after the termination. And as this court has said in GR, that doesn't count. We're not going to entertain anything that happens post-dependency, post-adjudication.
In many ways, if we reverse, are we really just reversing to send it back for a fairly perfunctory, you're the father, we kind of move forward?
And that presents a very unique question, and I've thought about that a lot. And the reason I think about that is the department's usual stance and the court's usual stance is once the rights have been terminated, you don't have any contact with the child. You get a goodbye visit, and then we're done. Right. And these cases take so long to adjudicate, and we fast-track them here for juvenile court, as you guys are aware. So even though that can take 6, 7, 8 months, these parents aren't going to have contact with their kids for 6, 7, 8 months while this works its way through the natural course. So given that, every case on appeal would then be an abandonment prima facie because they're going to have 6 months of no contact with their children. So to answer your question, I think it would go back, and then most likely, the department would then either motion or petition, depending on how this court's ruling came out, to terminate the parental rights, and most likely go to abandonment now that paternity has been established. And then I think it's incumbent on the father then to try to establish and maintain, and then have an argument of, I was not able to see my child.
But then isn't F going to come into play and say, look, you could have done this years ago. We don't need to give another 6 months. We've got the abandonment from the very beginning. And it seems to me that's one way it could play out. The court also could say, no, I'm going to give a chance to try and establish it.
Absolutely. I guess, but the question I would have is, does that want to prevent us from doing what's right and what's just? No, the answer I tell my kids all the time is no. Even if you're going to have the right result, do it the right way. So this is sometimes about, I think, wronging a right, and that's what we're asking you to do today. And with that, I would reserve the rest of my time. Oh, sorry.
In reading the statute, going to the plain language, I referenced A, and I referenced the lead-in to B. But don't we also then, unlike 5 and 6, 1 and 2 also say the parent. It doesn't refer to anything. So there are 3 different places, from my perspective, that show very clearly these 3 provisions require a parent before a termination can occur. Any disagreement with that?
No, and I think it's spot on. I think it almost stands to reason. Can you abandon somebody that's not your child? I would venture to say the answer to that is no. That paternity has to be established, that it has to fall in there.
And fair to say DCS has conceded that as to neglect,
Absolutely.
it has to be a parent.
Correct.
Okay.
So, thank you, and I reserve the rest. Thank you.
May it please the court, my name is Dawn Williams and I represent the Department of Child Safety, and it seems that this court is not as concerned about the jurisdictional issue perhaps. Am I correct in reading that we should go directly to the application of this ground? And it's the department's position that the legislature and this court and Arizona Supreme Court have made it clear that you can terminate the parental rights of someone who hasn't established their paternity of a child. The legislature did so by including grounds that referred to people who have not established their parentage. And this court and Arizona Supreme Court have for years acknowledged the termination of parental rights of fathers who had not established paternity, or even John Doe, an imaginary placeholder for such individuals. And so
is it an imaginary placeholder? It is the person with a name. So it is the actual parent who is that John Doe is standing for.
Right.
So I think that's a little different. We're not saying that you can terminate an alleged parent as a John Doe. You are only terminating the actual parent. There's one John Doe.
We're terminating any individual who may be the child's parent.
Who is, not maybe, who is.
Who is the child's parent.
So I think
correct.
John Doe is a little different.
Right.
Let's say we accept some of your reasoning. We ignore the fact that it says the parent-child relationship in A. We ignore the child relationship in the lead-in to B. How do I get around that 1 specifically says the parent, B specifically says the parent? The plain language of those 2 subsections and others specifically require it. And then there are other subsections that don't. Isn't that a fair way to read it? When the lead into the specific, and it should be paragraph actually, the 1 is a paragraph. When the paragraph specifically says the parent, shouldn't we read that to apply? Did the legislature make it clear that way?
And that's why we've conceded that the B2 ground, the neglect ground, was inappropriate here, because it does require the parent.
Okay.
B1 also includes the parent, but the legislature tacked on that subsection F, and that came many, many years later. And so in an ideal universe, would that be a separate ground? Yes. I think in hindsight and in light of all of this that we've been facing in the wake of GR, we certainly wish it had been included as a separate ground.
Sorry, can you clarify when was that adopted?
When F was adopted? Oh.
Do you know roughly? Within the last 10 years? Or?
No, it was more than that, but it was after the change in the definition of abandon. So once we got the definition that currently exists in 8201, the F was added.
It's been at least 20 years.
I think it was approximately 20 years ago, yeah, somewhere around there.
In terms of that, when I read subsection F, and then I know there's, as you've seen referenced in GR 25-813B. 813B is the actual mechanism that you wish now was a ground. in essence, that there was an order and they didn't follow the order. But that's not what happened. And isn't that the problem with trying to turn F from an evidentiary ground of abandonment, which I think if we were to reverse, your client is going to use, and say, look, there was evidence of abandonment before paternity was established, and we don't need any more time. We just need to go through the process, the discussion I was having with Mr. Johnson. But isn't it just an evidence of abandonment provision? It's not a new ground, and it doesn't establish paternity.
I think this court can read it in that because the actual ground, the B1 ground itself, just says a parent has abandoned the child. It doesn't include that entire definition of abandonment that appears elsewhere in Title VIII. And so I think this court can read that provision of F as a new subsection of that B1 ground. So instead of proving that the parent has failed to maintain a regular parental relationship without just cause for 6 months, as we would under a standard abandonment ground, now we have this other evidence that we have to show, and that's that the parent failed to take a parentage test. And once that's been shown, the alleged parent, then the court can find this parent has abandoned this child and has abandoned any potential parental rights this person may have.
But the legislature has chosen to define abandonment in two places identically, and both of those definitions also require a parent, correct?
In the 820.
In the definition.
Yes. Mm-hmm.
And so I again struggle with rewriting a statute and taking F and moving it up under B and making it a B1A, maybe, whatever you want to call it, because the legislature could have done that. Isn't it really something that perhaps your client wants to take down the street and change, but it's not something that we would rewrite?
I respectfully disagree that this court is rewriting the statute. I think this court and the juvenile court can and does apply that BF provision to permit termination under B1. And that in any event, and even in the B5 and 6 grounds, what the court is terminating is a parent's potential parental rights, the rights that they would have once they established paternity. And so that's what the court is doing here.
That's under B5 and 6.
Right.
But B1 says the parent. It doesn't say the putative parent. And that's an easy change the legislature could have made. And the legislature knows how to do it because they did it in 5 and 6. Isn't that kind of the way we read these things?
And as I'm trying to remember back to when I was digging into the legislative history of all this, and I believe that F and 5 and 6 all came about around the same time. So it really is, again, unfortunate that F is separated as it is. But I think it does evince the legislature's intent to have some mechanism for terminating the potential parental rights of individuals like Mr. D in this case, who don't step up, who don't do what they need to do.
But your client could have fixed that under 25-813 with a simple motion. It's not that your client isn't always stuck in we can't do anything because the parent didn't take the test. Your client does have an actual mechanism in statute to deal with that.
And I think the issue here is that the department has, for decades now, relied on B1 and BF to effectuate a termination in these cases. And so we haven't looked to the Title 25 statutes to do that. And that may be a way of remedying this going forward. But looking at the history of how this ground was applied, the department had every reason to believe that this was an appropriate termination ground, which was why it was pled.
I'm not suggesting the department acted in any kind of bad faith. But that doesn't mean that the interpretation is correct. So I'm just struggling with, aside from that, the fact that historically folks have kind of left that happen. I think historically they also did terminate or dependencies for non-parents. How do I read the statute? That gets any other way that I can read the statute to get you there?
I mean, if the court is inclined to require for any B1, even if it includes the subsection F to require a parent, then I think we're stuck. But the department reads it differently.
Yeah, is that reading consistent with the plain text of F?
It's challenging because in Ray GR, in footnote 5, the court said if a father doesn't establish paternity, you can just terminate his parental rights. And so it seemed to, again, turn us back to go ahead and use this provision if you get down the road past the dependency to the termination. And so that's how the department has read it, that the department can use F to prove an abandonment.
So I take it you don't agree with the premise that your view reads the phrase parent-child relationship out of A and B in 533, right?
It is a parent-child relationship in the sense that it's the potential rights that a parent could have.
That's what I was asking. I mean, I don't think that you think that you're reading it out of the statute. I think that you think that under B, there are a bunch of parallel subtypes of parental relationships, some proven, some not yet proven. Isn't that your position?
Yes, exactly.
Okay.
But fair to say, if that was the case, the way to make that clear for the legislature would have been potential, I mean, they've used three words, I think potential, putative, and alleged. They could have started subsection B, the alleged parent. That would have been the way to do it, not the way it's written. As
Right.
it is, that alleged or putative or potential is only in 5 and 6.
That's correct. And then F.
And in F, as it is.
So what's your position on the assertion by Father's Counsel that there was no request here by the department, that's not existing? So really, subsection F is not even, factually, is not at play here.
Well, the only evidence before the court is that the dependency, or the termination motion itself indicated that father had been, or the alleged father had been referred for testing at PSI and had not completed it. By failing to attend that hearing, the juvenile court found that he had admitted those allegations, so he has admitted that he was referred to testing at PSI and didn't do it. And then the testimony of the caseworker who testified she asked him to go do this test and he never completed it. The department was willing to not do that test and allow him to sign an affidavit or acknowledgement of paternity, and he failed to do that as well. So to the extent he is now claiming that there's no evidence in the record, his opportunity to demonstrate that was at the trial that he failed to attend. The uncontroverted evidence in the record is that he was asked to do that test and failed to do so.
And
But what's the formality? I mean, there's requested by the department. Can that be an email? Can that be a voicemail message? What's there's no guidance here. I mean, how long does that have to be outstanding? 3 days? 30 days? 60 days? 90 days?
Again, I think
There's no guidance here. So that to me makes me lean in favor of saying this is an evidentiary prong right here, that the court can give it the weight it deserves and not a separate ground for severance.
But I think, all of the grounds are evidentiary to some extent. I mean, you have to even...
Well, that one says the parent has abandoned the child, period.
But then we have the definition of abandonment that we have to meet to demonstrate what that means.
I understand that. They all have various components and definitions. For whatever reason, F is just stuck down at the bottom by itself. It could have been easily added to the abandonment definition. It wasn't. It could have easily been added under subsection 1. It wasn't. So I don't quite know what to do about that.
Was there an attempt in this record to show good cause for whatever the declination of taking the test was?
The only evidence in the record was from the mediation summary where it indicated that Mr. D said he wanted to do an acknowledgement of paternity and the department was willing to accept that. And then he indicated in his pro se opening brief that he had submitted something, but that appears nowhere in the record.
when we're looking at this, because again, subsection F doesn't say the department can establish paternity with this. It just says it's evidence of abandonment. The reality is, and again, the questions that come up, what is the evidence of a request? And if we're going to establish paternity based on that, there's a mechanism to establish paternity, and that's in Title 25. And what you're arguing is that this statute does two things. It establishes a mechanism under Title 8 to establish paternity independent of anything in Title 25.
Well, I would disagree. It doesn't establish paternity. It just indicates that someone has not established paternity. So
Okay.
I would disagree with my colleague's statement.
How do you write subsection B says the parent with the parent in or 1 says the parent and subsection 2 says the parent. The subsection 2 parent you acknowledge has to be the parent. Subsection 1 you're saying we can use F to get around it, but it's just saying the person failed. I don't know how you write that.
I think our reading is that subsection F, by using the same term abandonment, the legislature has linked those two and has said you can use this ground now for an abandonment finding for an individual who has failed to establish paternity or parentage.
And so I find abandonment, but I don't find parent. I struggle with that. But I don't know that we have any way to get around it.
I don't know that we do either. But, I would disagree that as counsel has indicated, DNA testing of the grandmother has indicated that she is biologically related to this child. So Mr. D's mother is biologically related. That did not establish his paternity. His paternity remains unestablished as far as I'm aware. And so.
I think it's just one more piece of evidence of paternity.
Correct. And of course, that was well post-termination before that information came to light.
So on this idea we've been discussing about, well, it's all just evidentiary, I want to ask a very sort of abstract question, which I apologize for it being abstract and not being exactly the facts of this case, which it is not. But I'm trying to interpret F and give F a fair reading. So in F it says, the failure to take a test, is prima facie evidence, not evidence, it's prima facie evidence of abandonment unless good cause is shown. So in a case, it's a hypothetical. I think we get to do that. So in a case, hypothetically, you have prima facie evidence because someone declines to take the test. There's nothing else in the record. There's no other contrary showing to rebut that prima facie showing. What result when you move to terminate for abandonment? If that's the only evidence, if the prima facie showing is all you have, what result?
Then the ground for termination is established, and then the court moves to the best interest inquiry.
And this is more a statement than a question. That's what I'm struggling with here. I get the point that it's evidentiary. I also know the word evidence starts subpart B, so it's all kind of evidentiary, like you said. But when it's prima facie evidence of abandonment, it isn't quite a ground, but it isn't not a ground. It seems like it's kind of in between. Any comment?
The same could be said then of the standard abandonment ground, because that also provides a prima facie case of abandonment for a parent who fails to maintain contact for 6 months. So in either event, once you've made that showing, you've demonstrated the ground. Then again, the court looks to, okay, we have a ground for termination. Do we have best interest? And that's where the court will look to the totality of the circumstances.
So if you have an aunt who has abused a child to meet the standard of the statute, yes, you have a ground, proven neglect, but you don't have a parent.
Right.
Same with abandonment. Yes, you have an abandonment. There's been no interaction with the child, but you don't have the first step. So an aunt didn't help the kid either. Maybe they were a guardian. We're not going to terminate their parental rights under that situation just because of that.
Well,
so
actually,
you still have to have the parent.
Under, which one is it? Is it 8? I can't remember which rule it is, but there is a rule that says that that the term parent also encompasses a guardian in these proceedings. So had we had an aunt who was a guardian of the child, her rights as a guardian of that child could be terminated under 8533. Although we typically would just revoke the guardianship.
I was going to say, I've never seen that.
Yeah.
Much easier to just
Exactly.
get rid of the guardianship.
Sure.
But doesn't that just go back to the point about 5 and 6? Because if you can just, by virtue of declining to take a test and there's no other facts in the case, escape being deemed a parent, that would just put an X through what F is. F would be meaningless at that point, and that logic is defeated by the presence of 5 and 6, no?
I'm sorry.
I mean, 5 and 6 are other cases where, the fact that a person doesn't have parentage established is because of their non-participation in or non-availability for the proofs. So the legislature seemed to think, well, no, we're going to terminate anyway, even in the absence of precision, in 5, 6, and in F, right?
That's correct, because we have cases like this where an individual may have been holding himself out as the child's father, may have been involved in the child's life, but never took the legal steps to step up to establish the full panoply of parental rights. And so 5 and 6, to some extent 9 and F, all address that situation so that we can ensure, because otherwise if we didn't have these grounds when we went to adoption, individuals like Mr. D could come in and contest the adoption, and that's going to delay permanency for this child, especially when he's already had a year of services offered and attempts to engage him in the life of his child, and he ignored that. And so in order to ensure that, okay, you got your chance, and that's why individuals who have not established paternity are included in these dependencies, because the idea is we want to keep kids together with their families if at all possible. So we
Have you ever seen the department allege 5, 6, or 9 as
I have.
standalone grounds?
It's
just
not-
only one ground?
It's not common, but it has happened. 5 is challenging and had been until, I think, fairly recently cost prohibitive in the sense that it was easier to terminate on abandonment than to go pay to get a certified copy of the putative father's registry. The B6 ground is difficult because it's triggered by the filing of a notice in an adoption, and the statute itself, 8106, refers to when the mother places the child for adoption, and in most DCS cases, of course, the mother is not placing the child for adoption, DCS is. So B6 is difficult for a DCS-initiated termination of parental rights, and so, we may be looking at how DCS can provide the notice in 8106. I'm not sure how, we're still figuring all of this out. So B6, not so much. We have used B5, we have used B9 for parents. We have historically used B9 more for mothers that we couldn't find than for fathers. Again, I think because you have these two ways to prove a prima facie case of abandonment, which is considerably easier.
Thank you.
And fair to say that usually the registry comes up just as a piece of evidence. The department gets the registry and says, hey, nobody's also filed. It's just one other piece that they throw in, but not necessarily a ground. I think that's what I've seen in most cases, is the department has just simply said, by the way, we served John Doe, and no one's filed anything in the registry.
I think the only time I know that registry searches are typically done is if we're alleging B5.
Yeah,
So,
okay.
and I say we, I mean the department, of course. I think we've covered everything. If the court has no further questions, I'll cede the rest of my time.
Thank you, counsel.
Thank you. Just a couple of quick clarifying things. I can tell you, Father Registry does not charge anymore. That change was made several years ago. So as we're talking about ways of going forward and doing things, that's no longer a charge. They provide you the certified copy free of charge. Of course, then it's just a delay of a couple of weeks to get it. Ms. Williams brought up footnote 5 from GR. And I just wanted, one thing that stands out to me in footnote 5 is the last line that says, if an alleged father fails to comply, the department may petition for termination. And again, I get stuck on the petition versus motion. And I think there's a reason why it says petition as opposed to motion. Again, recently, since GR, I've seen the department do the petition as a separate case. And I think that's in compliance with GR and in accordance with GR. But again, I think that's the proper mechanism to do it in a case like this. So, Your Honors, we just submit to the court that Father, he was not formally requested to do the paternity testing. And I understand Ms. Williams' position that, well, he didn't contest it, so then he's just deemed to admit the allegations. The court still, as a trier of fact, have an obligation to still look at the factual record and still make the requisite findings. They can't just take what's pled. They can't just take the testimony of a case manager and say, well, he's not here to contest it, so it has to be true. We simply, it doesn't happen that way. They have an independent obligation. And the trier of fact in this case, I have the utmost respect for. And I think had GR been out before that, we might have had a different result. But of course, we didn't have, hindsight's 20/20. So I think we're doing the best we can. But I don't think the argument that was made of, for decades, this is how we've done it, so we've never had to worry about it, is a valid argument to make when you talk about the parental rights of somebody hanging in the balance. So respectfully, we ask that this court vacate the termination at the minimum. If the court is inclined to do the dependency finding as well, then that would be great, but at the minimum, the termination finding, and send it back to the court.
Counsel, just I'd like to follow up on what you just raised. It is very important. So is it your position that just the record doesn't support that there was a request, or that whatever the record supports was not sufficiently formal to be deemed a request, so it was like informally requested, but it wasn't sufficient? Please explain.
So I agree with the court that I don't even know what a request means. When it says it in there that it's just a request, is it the phone call, is it the text message, is it the one time, is it they set up an actual PSI test and you failed to show? I don't think the record supports it at all. I think, there's 4 or 5 pages in the motion to terminate parental rights, a list out it's shotgunned out there, and the findings of fact conclusion of law are a copy and paste of that. I can't find it anywhere to be found.
I'm sorry. So when it says the department wanted him to establish paternity and gave him 2 options, that wasn't sufficient to establish a request?
What 2 options?
The 2 options were give a voluntary acknowledgement of paternity, or take this test that we referred you for. So it's been referred. Isn't that a request? When you say, look, you got 2 options, but we need you to establish paternity?
I think, You can construe it that way. I don't. I think when we're talking about the significance of what we're talking about, and I'm just going off the direct verbiage of that mediation order, that does not seem like a request. That seems more like a, we'll play it by ear and see
So
how
then
it goes.
Your argument is we don't even have to look at F. We're just looking at
100%.
D1 in the absence of an F
Right.
provision, and we should just leave F alone.
Agreed. But I also take the position of, even if you found F was satisfied, it doesn't matter.
Okay.
It doesn't fit. It doesn't, there's a reason why it's B1 and then F. It's not, as this court noted, it's not B13 and B10, it's an F. When you look at the plain language of 533, it says, may file a petition of termination of parent-child relationship alleging grounds contained in subsection B of this section. It doesn't say subsection B and F of this section. So,
I take your answer, and I understand what you're saying, counsel. But what would be sufficient to constitute a request? Because I'm stuck over here having to interpret what F actually means, and the legislature said request. So what's good enough to be a request from your point of view?
I think in the service letter, if in the court report it says father was submitted a referral to PSI for paternity testing, if it were anywhere, especially when you take in totality, the case manager says, I told him at the beginning. Well, I don't know if that's accurate because we don't see it again until a month and a half later in the mediation where she says, if you don't do it this way, then we'll do it this way. So I don't know, what does the beginning of the case mean with the onset? When this case was really short-lived in terms of dependencies, how they go. Thank you.
Counsel, thank you both for your arguments this morning. The court will take the matter under advisement and issue a decision in due course. The court is adjourned.